Land trusts are heavily promoted, but there are a ton of reasons why you should never set one up in the first place. What is a land trust in the first place? Well, at its basic level, it's a trust that holds title to land. And a trust at its very basic level is a three-party relationship, where you have the grantor, the trustee, and the beneficiary. The grantor is the person who sets up the land trust. The trustee is the person who holds legal title to the land trust, and the trustee's name is the one that appears on all the public records. And the beneficiary is the one who holds the property interest in the land trust as well as the beneficial interest. And the difference between the trustee and the beneficiary is that the trustee's name is on title to the property, whereas the beneficiary is the one who gets to use the property. There certainly are some perceived benefits with using a land trust. The first is that you get your name off the property. Because you're not the trustee, you don't have to list your name on the public records. And the second benefit is that when you set up a land trust, you use a trust agreement to do so. But the trust agreement is a private document. And unlike an LLC, where it needs to be set up with the Secretary of State, this trust agreement is not on the public record. Now, while there may be perceived benefits to using land trust, I'm going to give you 9 reasons why you should never use them in the first place. Number 1, some states don't offer land trust anonymity. As an example, when you set up a land trust in a state like Arizona, Arizona requires that beneficial owner to be disclosed to them. Number 2, beneficiaries are liable for any damage that happens on the property. There have been some cases in the state of Illinois that have held that when property is held in a land trust and there's issues with the property, the beneficiary is the one who is responsible for any negligence as well as any unpaid property taxes. And if you're liable for negligence and property taxes, that's really not a good asset protection strategy to use a land trust to begin with. And this brings me to point number 3. You need to set up 2 additional entities in order to use a land trust. Because beneficiaries are liable for any issues with the land trust, in order to limit their liability, you need to set up an LLC to own your beneficial interest. And on top of that, the trustee usually sets up an LLC to own an interest in a land trust as well. So to help explain this concept, I'll show you 2 options. One where you use the land trust and one where you don't. So with a land trust, you need to set up the land trust itself. You need to set up another LLC to be the trustee of that land trust. And on top of that, you need to set up a second LLC to be the beneficiary of that land trust. So to set up a land trust, you need 3 entities in total. And the second option is the one where you don't use a land trust. And what do you need for this? Well, you only need 1 LLC to hold title to that property. So in option 1, you needed 3 entities. You needed a land trust to hold title to the property, an LLC to serve as trustee, and a second LLC to be the beneficiary. But in option 2, you only needed 1 LLC to hold title to the property. And if you so choose, you could set up a second LLC that can be your holding company. And this brings me to point number 4. Land trusts cost way more money to set up. As I just mentioned, to properly protect yourself with a land trust, you need to have 3 entities in total. But if you set it up the right way, you only need 1 LLC to hold title to the property. And with the right structure, it could save you hundreds, if not thousands of dollars in setup fees. And for the companies who set up land trusts, they're the ones that are making a lot more money. Number 5, if you care about anonymity, you could hire a nominee manager instead of setting up a land trust. Now, a nominee manager is a person who's listed as the manager of the LLC on the Secretary of State's website. And the benefit here is that instead of your name being listed on the Secretary of State's website, the nominee manager's name is. And I should mention that this is totally legal. So if you care about anonymity, it's best to just set up an LLC and use a nominee manager instead of using a land trust. Number 6, There's issues with service of process when a land trust is sued. When a land trust is sued, the process server goes to the trustee to serve process. However, the trustee must then turn around immediately and notify you that your land trust has been sued. But there have been instances where it's hard for the process server to find the trustee. And this is a really big issue. This is because when somebody files a lawsuit against the property, you want to turn around and notify your insurance company as soon as possible. But if you use a land trust and it's hard for that process server to find the trustee, you could run the risk of having a default judgment entered against you and your property. However, you can simply avoid this scenario by just setting up an LLC to hold title to your property. When the LLC gets sued, the process server goes to the registered agent address and they accept service for you. And in turn, the registered agent immediately notifies you that a lawsuit's been filed against your LLC. So when you use an LLC with the professional registered agent service, they'll notify you as soon as possible. But with the land trust, because it may be hard to find the trustee, you run the risk of having a default judgment entered against you. Number 7, land trusts involve additional documentation that LLCs don't. So when you set up a land trust, you must have a trust document as well as a beneficiary assignment document. And having these on hand is very important. This is because it's very easy for a land trust to change beneficiaries. And because these documents aren't recorded in the county recorder's office, you must have them on hand with you. And if you don't have them on hand, this can cause some big issues in the future, especially if the beneficiaries change. And this brings me to point number 8. With a land trust, you could very easily run into title issues. And the issue here involves muniment of title. So what is muniment of title anyway? Well, muniment of title refers to deeds or other written documents to show who owned the property. And in order to show this ownership, you must file documents in the county recorder's office. But because land trusts are private documents, you could very well run into issues with muniment of title. And this is because with land trusts, it's very easy to add and subtract beneficiaries. But if there's no record of who was a beneficiary when, then there's no muniment of title. And if there's no muniment of title, meaning that there's not a documented record of who owned the property, then that land trust could very well escheat to the state, which is something that you don't want to have happen to you. How do you avoid this situation anyway? Well, you could just use an LLC to hold title to your property and then file the deed with the county recorder's office, because in that situation, you won't have any issues with muniment of title. And number 9, any transfer of a beneficial interest is a taxable event in the eyes of the IRS. So when you transfer beneficiaries in a land trust and there's any gain or loss on the property, the IRS recognizes that as a taxable event and you're going to have to pay tax on that transfer. Those are the 9 reasons why you should never use a land trust. Now, fortunately, there's some people out there like Pace Morby who've called out this practice. So thanks for that. But there's still a lot of promoters out there who promote the use of land trusts. While land trusts may get your name off the property, there are a lot of issues associated with them. And because of that, we recommend not using them at all. I also have a new book called The 5 Tricks to Teach Your Kids About Money. You can download the book for free by clicking the link in the description below. If you're looking to start a business, you can schedule a free 15-minute consultation with us at Corporate Direct by also clicking the link in the description below. And as always, please make sure to like, subscribe, leave a comment, and turn on that notification bell. And I should warn you, the contents of this video are not legal advice and no attorney-client relationship has been formed.